My dear friends, my name is Umesh Rao. I have completed my law degree in 1985. My today's subject is interpretation of statutes, internal aid to construction of statutes. I have prepared these notes to my friends, law students. I have prepared it in a very easy to read, listen, and remember manner. I advise you to read the textbook once and concentrate on these points prepared by me. I have tried to give the best material. If any of you finds any problem, kindly contact me through my email. Today's topic is what is the aid to construction? What is internal aid to construction of statutes? Title and its limitations, preamble and its limitations, heading and its limitations, marginal notes and its limitations, proviso and its limitations, illustrations and its limitations, explanations and its limitations, schedules, definition, and punctuations. First, what is the aid to construction? Aid means assistance or help. Help means help by the courts for construction of an ambiguous words. You know, the object of interpretation or construction is to draw the true intention of the legislature from the words used in the language. When words suffers from ambiguity, then it necessary to remove the same by constructing it. When the words used in the statutes bear more than one meaning, then use the meaning which is in tune with the legislature's intention. So aid to constructions can be called under the specific circumstances as detailed below. When words used in the language bears more than one meaning. Second, where there is uncertainty about meaning of the words. Third, it is not clear which meaning of the word should be assigned. Fourth, when there are several meanings of the word and which meaning has to be taken in the language of the statutes. Fifth, where more than one construction of language is possible, which one should be held? Then use of the plain and ordinary natural meaning of the word should be taken. Is it? So there are two kinds of constructions. One internal aid and external aid. Internal aid means it is various parts of the statute book. External aid means it is the material we are taking from outside the source. So what is the internal aid? It is the various parts of the same statute courts take into service for various construing of the statute. It is used to ascertaining the correct meaning of an ambiguous word. It is used when the intention of the legislature cannot be inferred from the language. Internal aid includes title, it may be short title or long title, preamble, heading, marginal notes, illustrations, provisos, definition, and punctuations. Now we will discuss one by one. What is title? Title is a part of a statute. Title is given on the top of the statute book. Earlier it was not considered as part of enactment and not used for the purpose of interpretation. Now it is used for ascertaining the general scope. Title always cannot override the meaning of the enactment. Title of a statute gives an idea as to what subject matter the statute deals. There are two kinds of titles, one short title and another long title. What is short title? Short title means it is nickname. Normally every act of parliament should have short title within the year in which it was passed. For example, Code of Criminal Procedures 1973, Code of Civil Procedure 1908. Title is always given on the top of the statutes book Object of the short title is identification of the subjects. Long title. Long title of an act is mentioned in the statute book in small letters below the short title and before the preamble. Example, short title in this case is the Consumer Protection Act of 1986. Below that it is written an act to provide for better protection of the interests of the consumer and settlement of consumers' disputes. This is long title. Long title gives the general description of the subject of the act and purpose of the act. Long title is used in resolving the ambiguity in a statute. In the past, long title was not considered as an aid. Now it is considered as an aid to construction. Now, what is the limitations of the title? Where the words of the language are plain, the title has no role, no use. Title can be used as an aid when there is an ambiguity. Title cannot be used to restrict the plain meaning of the statutes. It cannot prevail over the clear meaning of the enactment. Another topic is preamble. Preamble is a statement given in the statute in the beginning. It is a part of the act which explains the scope, object, purpose. It gives summary of statutes. It is a gist of law. It convinces the main objective of the legislation. It is a key open to the mind of the legislators. It is admissible aid to construction. When the language of the act is clear, preamble has no role. Preamble can be used to know the aims and objects of the legislation. Limitations of the preamble. It cannot be used as long as words are clear. It can be used when the language gives alternative meaning. It cannot override the enacting provision. When the provision of the statutes does not accord with the preamble, provisions cannot be invalidated. Next one is heading. Headings are attached to each section just preceding the provisions. Headings are not passed by legislatures. They inserted subsequently after the bill has become law. There are two kinds of headings. Headings which are prefixed to a section and headings which are prefixed to a group of sections. Headings can be used as an aid while construing a section. In case of conflict between the plain language of the provision and the meaning of heading, heading will not control the meaning. Only in case of ambiguity, headings may be referred as an aid. The limitation of headings. Headings cannot be used when words are capable of giving only one meaning. When the language of the provision is open to more than one construction due to uncertain meaning, then only heading can be used. Headings are neither cut down nor expand the plain meaning of the words. Headings cannot control the clear meaning of the words of the enactment. Now, marginal notes. What is marginal notes? Marginal notes are those notes which are printed on the side of the section in a small print. These notes are the summary of sections. In the past, marginal notes are not referred as an aid to construction. These notes are inserted by the draftsman and not by the legislatures. They inserted not under the instruction of the legislature. These notes are not part of the statutes. They don't carry authority of law. Side note is one which are guide to the scope of the section. Marginal notes can be used for interpretation where mistake has been found. They cannot take away the effect of the provision. When meaning of the section is clear, marginal notes cannot control interpretation. In exceptional cases, legislatures themselves insert marginal notes. Marginal notes appended to the Article 286 of the Constitution of India is part of the Constitution because it furnishes some clue to the meaning and purpose of the article. Limitations of the marginal notes. Marginal notes are rarely used for interpretations. Only those marginal notes can be used for construing the provisions which have inserted with the consent of the legislatures. If the words of the provisions are clear and plain and gives meaning, marginal notes cannot be used. It can be used only when the language suffers ambiguity. Marginal notes cannot control the plain meaning of the enactment. Marginal notes cannot frustrate the effect of clear provision. Next one is proviso. In some section of a statute, after the main provision is spelled out, a clause is added with the opening words provided that. The part of the section commencing the words provided that is called proviso. The part of the section commencing the word provided that is called proviso. The function of the proviso is to qualify something or exclude something. Proviso is added to give exceptions to the main provision, thereby removing something from its scope. Normal function of proviso is to accept something out of the enactment or qualify something. Proviso neither provides something by way of addendum nor deals anything which is foreign to the main enactment. The limitations of proviso. Proviso is construed in relation to section which is appended. If something is mentioned in clear words in enactment, proviso cannot be used to nullify the same. The scope of the section cannot be widened or curtailed by proviso. Proviso cannot be used to frustrate the real object of the main enactment. Proviso to a section cannot be used to import something which is not there. Next one, illustration. Sometimes illustrations are appended to a section of a statute in order to explain the provisions of law. The purpose of the illustration is to make the meaning of the section clear by giving example. They are considered as good aid as they help to explain the principle of the section. Illustrations cannot be used to defeat the provisions or to modify the language of the section. Illustration is part of the section and it cannot be ignored. Illustration should not be read as extending the meaning of the section or restricting its operation. The limitations of illustration. The illustrations are of little use as they are not considered as part of the statutes. When words the provisions are clear and give only one meaning, illustration cannot be used. Illustration can be used only when language is ambiguous and more than one construction is possible. Illustration cannot curtail or expand the scope of section. It cannot modify the language of the section. It cannot control the real context of the section. Next one is explanations. Explanation is appended after the statutory provision. Explanation meant to further clarify the meaning of the defined word. Explanation is to explain and not to enlarge the scope of the section. Object of the explanation is to explain the meaning of the act. When there is vagueness in the main enactment, it is clarifying the same. It gives additional support to the act. Limitations of explanations. It cannot curtail or enlarge the scope of the section. It cannot control the plain meaning of the words. It cannot modify the language of the section. Explanation is to explain the meaning and to remove any doubt. Now, schedules. Schedules are added in the end of the enactment. It is considered as part of the statute. Use of the schedule is to avoid matters with excessive details. When the words in the statutes are doubtful and uncertain meaning, schedule may be used to determine the meaning. Next one, definition. Modern statutes contain definition in the beginning in itself. The definition provides the meaning of the words used in the statutes. The purpose of the definition is to avoid the uncertainty of the meaning. Definition settles the meaning of a particular word. Definition should give some same meaning everywhere. Definition helps in interpreting a particular word. Object of the definition is to make clear the meaning and scope of the words used. It is not necessary to describe the meaning and scope of the words used in the statute. Definition is not to be read in isolation. Definition should not be restricted or expanded by importing elements from other legal systems. Punctuations. In earlier days, statutes were used without punctuation and courts were not concerned with looking at the punctuation. In modern times, statutes contain punctuations. Whenever matter comes before the court for interpretation, the court first look into the provision as they are punctuated, and if they feel that there is no ambiguity while interpreting the provision, they shall so interpret it. While interpreting the provision in the punctuated form, if the court feels ambiguity, the court shall read the whole provision without punctuation, and if the meaning is clear, the court have to interpret it without attaching any importance to punctuations.